The topic of hidden assets is a major issue for many clients who first ask us for assistance at various stages of confiscation proceedings. Now, those proceedings might be in accordance with the Criminal Justice Act 1988, it might be the Proceedings of Crime Act 2002, but we're often approached by defendants when the prosecution believe, or the court has already determined, that hidden assets exist. And the defendant will almost always say, I don't have hidden assets, no matter what the prosecution says. I can't afford to pay a prosecution, including pay a confiscation order, including hidden assets. Can you do something about it? Now, the answer to that depends on the stage reached in the confiscation proceedings and what has happened before the defendant asks for advice. But understanding the burden of proof is critical. And the basic position in confiscation proceedings is this. It is for the defendant to prove that he or she is worth less than the figure representing criminal benefit. Now, I don't want to comment in detail about the meaning of criminal benefit here, but once the prosecution brings sufficient evidence of hidden assets, it's then for the defendant to prove on the balance of probabilities that he or she does not have hidden assets. Now, defendants often complain that the prosecution sometimes make wild assertions about the existence of hidden assets in order to inflate the confiscation order and almost produce a second prison sentence by effectively obliging the defendant to serve the sentence set in default of payment. There have been many cases where a hidden assets argument has dissolved upon being properly challenged, but the prosecution is in a comfortable position where a reasonable degree of evidence exists. And if that is sufficient to shift the burden of proof onto the defendant, dealing with that issue needs to be very carefully considered. So there's no secret to dealing with hidden assets. It needs to be clear, there needs to be good documentary evidence, and that really underpins all of the preparation. The first stage we would normally come to, unless we're instructed later down the line in the confiscation proceedings, is providing the statement of means. So at the start of a confiscation timetable, the court will usually direct the defendant to produce a statement of means, unless the assets are already obvious to the prosecution or they have a statement of means because of related restraint proceedings. But the importance of that statement of means is often underestimated. Defendants will sometimes try and hide the existence of a vehicle, bank account, property, or another asset, and sometimes they're successful. But many defendants decide not to disclose because they're simply unaware of the powers available to the prosecution to obtain that information. Investigating officers can often make financial inquiries without the defendant even knowing about it. And the consequences of failing to disclose assets can amount to contempt of court. And it also invites a hidden assets argument. So in short, it can damage or destroy a defendant's credibility across a range of issues in the case. So solicitors will usually try to obtain instructions using really a comprehensive questionnaire that goes through each of the issues covered by, as it is, Section 18 of the Proceedings of Crime Act 2002. That's normally the legislation you're dealing with. And that will include references to real property in the UK, abroad, cash, bank accounts, vehicles, significant debts, other financial issues, and providing good quality answers to those questions is the first step in avoiding a hidden assets argument. The question we often get, what if an asset is jointly owned? Still needs to be disclosed, but the joint ownership should really be highlighted because the prosecution need to be aware of just how easy or difficult it is going to be to realise an asset. That can affect the asset's value. Many problems occur after a confiscation order has been made because a jointly owned asset has not been properly valued at the outset. The status of a co-owner in confiscation proceedings is a tricky issue. I don't propose to go into detail here, but it is more important in terms of intervention at the enforcement stage. Once an investigating officer then has the statement of means, the prosecution will allege a certain level of criminal benefit, and they will make some proposals about the level of realisable assets, the value of those assets in the statement of means. The existence, the ownership, value of some assets might be absolutely obvious, but a court will often decide the defendant has hidden assets where an item clearly existed and has subsequently disappeared without any satisfactory explanation. So a defendant will often say, for example, I sold the car to someone who used to work at the garage, I don't have his number anymore. If that's the extent of the evidence, the prosecution will ask the court to find that the defendant simply hasn't discharged the burden of proof in demonstrating that he no longer owns or controls that asset. So it's very important to provide as much detail as possible, particularly where cash is concerned, and this might include statements from individuals who can support the defendant's version of events, documentary evidence showing why it was necessary to use cash as opposed to an electronic transfer, that kind of thing. Another important issue is explaining the expenditure. It's a fundamental part of the assumptions in the Proceeds of Crime Act. For example, in the context of hidden assets, a defendant needs to show that if the money was withdrawn from a bank account, it, for instance, went towards purchasing an asset which can be identified or valued, or was used to, for instance, pay an identifiable bill. Many confiscation orders contain hidden asset elements because a defendant has not sufficiently explained domestic or commercial liabilities or the debits from a relevant bank account. And documentary evidence is very important. And this part of the process is often the most laborious. But each transaction a defendant explains is a reduction in the potential default sentence when it comes to hidden assets. It's not just an artificial exercise. But what if the transaction doesn't have the documentary evidence, or the defendant cannot remember what the transaction was about? Now, this arises particularly where I represent a corporate defendant who operates partly on a cash basis. Construction companies, haulage firms, cash and carry, fast food outlets are prime candidates. And the answer usually lies in the accounting records. In other words, general reconciliation between the cash payments and the firm's cash liabilities is sometimes the best anyone can do. And in those circumstances, it might be possible to argue that the defendant has done as much as possible to explain that transaction. It's not ideal, but arguing that an injustice would arise if the court found against the defendant is not straightforward. The court usually responds to a defendant who has used their best endeavours to provide the evidence. Another problem, often sometimes called boomerang assets, they're not strictly hidden assets I'm describing, but the prosecution will sometimes argue the defendant has tried to place an asset in someone else's name at the point of purchase, or temporarily transfer the asset artificially to someone else in anticipation of proceedings, so as to frustrate the confiscation process. Now, that can be as simple as arguing that a vehicle belongs to a spouse, but some of these transactions can be very complex. I've been involved in cases where defendants' assets were documented in someone else's name outside the UK, many different investment products, trust funds, companies, and attributing each element to the defendant can be a mammoth task. But investigating officers are becoming more skilled, and they're obtaining more cooperation from their partners abroad to bring that audit trail back to a defendant. It's sometimes said that officers are quite overzealous when an asset is worth a lot of money, even if the link between that asset and the defendant is fairly tenuous. But that brings us back to the burden of proof. The officer doesn't need to produce a complete watertight audit trail. Some of an officer's submissions in terms of ownership are sometimes surprisingly general. The officer only needs to produce sufficient evidence to place the burden on the defendant. And although the defendant only needs to convince the court on the balance of probabilities that the asset belongs to someone else, it's better to avoid the argument in the first place. Even if the defendant is telling the truth, any litigation carries a risk of an adverse decision. So it's very important to clearly identify the way in which the asset was purchased, and that might mean obtaining expert accountancy evidence. But what if the court considers that a hidden asset exists? Can they still make an order in a sum that's less than the benefit figure? A client can be absolutely stunned when a court makes an order, something like this. If the criminal benefit is £1 million, their identified assets in terms of their house, vehicles, bank accounts, etc. might be, let's say, worth £100,000. Hidden assets, unknown, confiscation order, 1 million, not £100,000. The client will typically come and say, why on earth did this happen? What can you do about it? So does it automatically mean that the defendant has not satisfied the court on the balance of probabilities that he's worth less than the benefit figure? And if so, is the judge bound to make a confiscation order in a sum equivalent to the benefit figure? Or can he arrive at a figure which is somewhere between the benefit figure and the value of the identifying assets? That's something that the court considered in the case of Leroy McIntosh and Michael Marsden, a 2011 Court of Appeal case, and that dealt with the way in which the court should approach and determine realisable amounts. It dealt with a number of other cases, Telly v Revenue and Customs Prosecution Office. It reviewed some of the aspects of May, House of Lords case in 2008, and then Glaves v the Crown Prosecution Service in 2011. In the case of Leroy McIntosh and Marsden, the benefit was agreed to be a little over £3.5 million, and the appeal concerned the proper approach the court should take, where a defendant was found not to have told the truth about his realisable assets. The appellants argued that the judge failed correctly to apply the provisions of Section 71 of the 1988 Criminal Justice Act. The defendant said they had no realisable assets. The judge disbelieved both of them. The judge regarded his finding that the appellants had hidden assets as compelling him to make a confiscation order in the full sum of the benefit figure. So he made a confiscation order in the sum of £3.5 million, well, over £3.5 million. Defendants appealed, argued that even though a court may reject a defendant's evidence that he has no assets or only some assets, the court isn't bound to make an order in the full amount of the benefit. Now, Section 71, or part of it, provides that subject to subsection 1c, the sum which an order made by a court under this section requires an offender to pay shall be equal to the benefit in respect of which it is made, or the amount, and this is the important word, appearing to the court to be the amount that might be realised at the time the order is made, whichever is the less. Sounds fairly complex, but the provision requires the court to assess what amount appears to the court to be realisable. And the burden of proving that the amount that might be realised is less than the benefit figure is on the defendant. Officers usually raise the case of Barwick, a 2001 Court of Appeal case for the authority, that the nature and value of the assets are essentially within the defendant's personal knowledge, so they're the ones who should know what to tell the court about the assets. However, officers don't often emphasise the fact that although the judge in Barwick disbelieved the defendant, the judge nevertheless concluded that the realisable assets were less than the amount of the full benefit figure. I think the phrase he used was doing as broad a justice in this case as I feel able to do. The Court of Appeal upheld the factual conclusions and his acceptance that the realisable assets were less than the full amount of the benefit, even though the defendant's evidence hid the truth. In the case of May, it was Lord Bingham who said that it would be unjust to imprison the defendant for failure to pay a sum he cannot pay. That's fine as far as it goes. But he also stressed that that needs to focus on the statutory regime. So although he acknowledged what Lord Steen said in the case of Revsey, the 2002 Court of Appeal case, you need to stand back and decide whether there is or there might be a risk of serious injustice. You can only do that within the statutory regime, within the confines of the statute itself. And Bingham made it clear that the injustice in ordering a defendant to pay more than he was able to was recognised by or catered for in the provisions of the statute itself. It's also been recognised that it would be unjust to imprison a defendant for failure to pay a sum which he cannot pay. Consequently, the provision's been made for assessing the means available to a defendant. And if that yields a smaller figure than the benefit, then making a confiscation order in the former, not the latter sum, is appropriate. So there's no real room outside the statute for any residual discretion for the court to relieve a defendant who's failed to prove that his assets are less than the full amount of the benefit. But it needs to be deployed in the statutory scheme. And the court has to really try and achieve justice and proportionality within the confines of that regime. And they need to go back to Section 71, whether it appears to the court that the realisable amount is less than the amount of the benefit. Now that can lead to a situation where if a defendant fails to satisfy a court the value of the realisable property, then the court, the value of the realisable property is less than the benefit figure, then the court is bound to make a confiscation order in the full benefit figure. And the defendant should not, if you follow the statute, be able to avoid an order recovering the full benefit unless he properly identifies the realisable asset he holds. And if he refuses to do so, then the court has no option but to make the order in the full amount. Now this is significant to defendants who agree confiscation orders, including an element of hidden assets, and then they seek what's referred to as a certificate of inadequacy or an application according to Section 23 of the Proceedings of Crime Act 2002 in relation to those hidden assets when they're about to embark upon their default sentence, because often it's completely inappropriate and Section 23 just doesn't apply to that situation. An appeal, very difficult, may not apply to that situation, but those are often instructions you get in those situations. So does all of this mean then that in any case where a defendant has been found to have lied and diminished or hidden the true value of his assets, then the court is bound to make an order in the full amount of the benefit? Well, no, it doesn't, because in light of the case of Glaves and May, there is no principle that a court is bound to reject a defendant's case that his realisable assets are less than the full amount of the benefit, merely because it concludes that the defendant hasn't told the truth. You need to go back to Section 71 and ask the question. The court may conclude that a defendant's realisable assets are less than the benefit on the basis of those facts as a whole. A defendant who's found to have not told the truth or has not given proper disclosure is going to find it more difficult, but it may not be impossible for that defendant to do so. Other sources of evidence, apart from the defendant himself, a view of the case as a whole may persuade a court that the assets available to the defendant are indeed less than the full benefit. Now, going back then to the McIntosh and Marsden appeal, the appellants asserted that the judge's view was that he was bound to make an order in the full amount of the agreed benefit. once he'd rejected the appellant's case, that they had no realisable assets. And the appellants focused on a passage where the judge had quoted something from the case of Telly, and he said, in my judgment, it follows that once the benefit under the 1988 Act is established, if a defendant refuses or fails to identify all his realisable assets, or fails to satisfy the court on the balance of probabilities that he has no hidden assets, the court has to make a confiscation order for the full benefit figure. Now, the judge said that McIntosh's case should be read in conjunction with his judgment in Marsden, and concluded that the consequences of my finding are that I am not satisfied on the balance of probabilities that Mr. McIntosh has established that he has no assets with which to pay the criminal benefit attributed to him. And in accordance with my judgment in Telly v. the RCPO, the only order I can make is a confiscation in the sum of, it was over $3.5 million. Now, 2 weeks earlier, the same judge had made a confiscation order in the case of a fellow conspirator, a chap by the name of Moen. Now, he found that the defendant had lied about his assets, and that the full value of the benefit to Moen was a little over $2 million. But nevertheless, he went on to make an order which was much lower than the sum of that benefit. The order was in the region of just under £100,000. And the judge said, whilst he's not been frank and honest about what his assets were, even the Crown do not suggest that he would have sums anything like near that benefit figure. And despite what is said in Telly, it would be wholly wrong for the judge to make an order in that sum. So consequently, one needs to recognise that a just and proportionate view of the facts as a whole may enable a defendant to satisfy the evidential burden, even when his own evidence proves to be untruthful or unreliable, or even non-existent of the nature and extent of his current assets. So McIntosh argued both at the confiscation hearing and on appeal that the amount of the agreed benefit was far higher than the reward he'd ever received from his participation in the conspiracy, and that the assessment of the amount of his realisable assets must have been far less. Accordingly, even if the judge rejected his case that he had no assets available, the amount ordered should have been substantially lower than the value of the benefit. Court of Appeal rejected that and referred to the judge's detailed comments on the facts. McIntosh's appeal was rejected. Marsden's case, judge found the value of the defendant's assets outside the UK was totally unknown, and that was crucial, because once the judge had reached that conclusion, there was no real basis upon which he could conclude that the value of Marsden's realisable property was less than the value of his benefit. And the Court of Appeal decided that neither justice nor a sense of proportion demanded that the judge should conclude that assets abroad, the extent and value of which were unknown, should be assumed to be of a lower value than the full benefit figure. And Marsden's appeal was then dismissed as well. So in summary, it's up to the defendant to prove that he's worth less than the sum representing criminal benefit, and the court can make an order in an amount less than the benefit figure, even if a defendant's evidence is disbelieved. However, a defendant is going to find it more difficult to discharge that burden where the truthfulness of his account is called into question, or he declines to provide the information at all. And the best way to persuade the court is to properly disclose the existence of assets and what has happened to those assets the defendant either no longer owns or controls. And providing documentary evidence and showing best endeavours are very, very important. And the cases of McIntosh and Marsden show that appealing in the absence of those elements is likely to be very difficult indeed. So that's a fairly lengthy, fairly complex review of the kind of situations that people come across and the kind of advice that people ask for when they encounter hidden assets. I hope that's been helpful. Thank you very much.